for any homework-related queries. Call us at +1 678 648 4277. You can mail us at info@lawhomeworkhelp.com or reach us at www.lawhomeworkhelp.com. lawhomeworkhelp.com. Problems. Please write a short, 1200 to 1500 word paper addressing one of the following topics. 1. Consider this proposal. Someone should be held legally responsible for a harm if and only if her action was a necessary condition for the harm's occurring. Is it true? Might it sometimes be appropriate for someone to be held legally responsible for a harm even if her action was not a necessary condition for the harm's occurring, even if, that is, the harm would have occurred regardless of how she acted? If not, why not? If yes, give some examples to defend your view. Might it sometimes be inappropriate to hold someone legally responsible for a harm, even if her action was a necessary condition of the harm's occurring, even if, that is, the harm would not have occurred if she had not acted as she did? If not, why not? If yes, what distinguishes the cases where the person should be held legally responsible for the harm for which her action was a necessary condition from those where she shouldn't be held legally responsible? Be sure to explain and illustrate your proposal by applying it to examples, and defend it against possible objections and counterexamples. lawhomeworkhelp.com. As a reminder, here are some of the candidate principles of legal responsibility from the Hart/Honoré reading and class discussion that you may want to consider. A person should be held legally responsible for a harm for which her act was a necessary condition if and only if no other fully voluntary act intervened. The acts leading to the harm wasn't the result of a coincidental event. The act was morally wrong. The act was voluntarily performed. If you consider any of these principles in your argument, be sure to explain what they mean. 2. Thompson distinguishes individualized and mere statistical evidence. Explain what, on Thompson's view, this distinction amounts to. What features does individualized evidence have that merely statistical evidence lacks? Consider a minimal pair of cases of individualized v. mere statistical evidence. In one case, we have individualized evidence that determines that an accusation has probability n, while in the other case we have mere statistical evidence that also gives the accusation probability n. lawhomeworkhelp.com. Thompson, like many others, thinks that the evidence in the second case is an inappropriate, or at least less appropriate, basis for legal decisions. Explain what you think is the best argument for the claim that individualized evidence is more valuable than mere statistical evidence. It could be an argument discussed in the reading or in class or your own original argument. Is this argument ultimately successful? If you think it is, defend it against an objection. If you think it isn't, explain what you think is wrong with the argument and assess a response on behalf of the friend of individualized evidence. 3. Explain Cushman's blame-blocking hypothesis and why he takes his experiments to support it. Do you think the experiments support Cushman's hypothesis? Why or why not? How else might the data be explained? Can we learn anything from Cushman's experiments about what moral judgments we ought to make? Explain your answer. 4. Do you think it is appropriate to punish criminal attempts more severely if they succeed than if they fail, or to punish one of two acts more severely than the other if it had more harmful consequences, even if the difference between success and failure, or the difference in harms caused, seems to be purely a matter of luck? Why or why not? lawhomeworkhelp.com. As part of your argument, consider and evaluate Lewis' somewhat half-hearted defense of differential punishment by appeal to the notion of a punishment lottery. Do you think Lewis' argument succeeds in establishing the justice of differential punishment for successful and unsuccessful crimes? Do you think there is a better way of justifying our practice of differential punishment? Or do you think it is ultimately unjustifiable? Be sure to defend your answer against possible objections. 5. Why should we punish criminals? And how much should we punish them? Why? In defending your answer, be sure to consider possible objections to your view. Think about possible direct objections to the principle of punishment you defend, as well as examples of particular, possibly hypothetical, cases where the punishment your principle recommends may seem intuitively objectionable. LaHomeworkHelp.com. Solutions. The punishment that leaves something to chance leaves something out. A response to the punishment that leaves something to chance by David Lewis. Introduction. In his paper The Punishment That Leaves Something to Chance, David Lewis looks for a justification for differential punishment. For the purpose of this paper, I will consider differential punishment to be punishment, or a policy of punishment, that punishes attempts at criminal acts differently than successful criminal acts. Lewis argues that the current, American, system of differential punishment is a disguised form of a penal lottery, in which a convicted criminal's punishment is determined by chance. Lewis 58. Lewis does not claim that either a system of punishment based on a lottery or the current system of differential punishment is just, nor does he claim that either is unjust. He claims that if and only if a penal lottery is just, is our current system of differential punishment one just. LaHomeworkHelp.com. In this paper, I will briefly discuss moral luck and penal lotteries, and reconstruct Lewis's argument that there is no relevant difference between a penal lottery and our current system of punishment. While I am sympathetic to the similarities Lewis points out, I will argue that there is a significant difference between a penal lottery and American differential punishment, which justifies differential punishment but not a punishment lottery. Moral luck. It seems unjustified to punish a person based on whether they are lucky or unlucky. Consider the following situation, where the only relevant difference between a criminal act being an attempt and being a success has to do with luck. Two agents both shoot a victim at point-blank range. The agents acted with the same intent, had the same marksmanship, used equally deadly guns, etc. The only difference is the first agent's victim is saved by an unlikely, unrelated act. A bird flies between the criminal and the victim and ends up absorbing the bullet. This unlikely act seems to be an instance of luck, or lack thereof, for the criminal agent. Both criminals acted with the same malicious intent to kill, are equally dangerous or wicked and therefore seem to deserve the same punishment. Lewis 53-54. This raises the question of focus: is differential punishment justified, and if so, on what grounds? LaHomeworkHelp.com. Punishment lottery. In this section, I will reconstruct Lewis's concept of a penal lottery. The severity of the punishment assigned to a convicted criminal is determined by chance, a lottery, if you will. In a penal system based on a punishment lottery, instead of definitely punishing a convicted criminal, he or she is only put at risk of punishment. Lewis 58. He distinguishes between a pure and impure penal lottery. In a pure penal lottery, any convicted criminal who wins the lottery does not suffer any punishment. Lewis 58. In an impure penal lottery, the losers and winners of the lottery both suffer, but the loser is subject to worse punishment. Lewis 58. Lewis points out that a penal system based on a punishment lottery does not need to specify the mathematical risk of punishment, so long as it is common knowledge that committing prohibited acts implies a risk of punishment. Lewis 58. Iterative process from punishment lottery to American system of punishment. Lewis argues that there is no difference in the justness between an impure penal lottery and our current system of differential punishment. Lewis 63-66. By iterating through several schemes of punishment, making small changes to the punishment process in each step. A similar but simplified version of his argument is presented below. LaHomeworkHelp.com. To make the argument less confusing, I use murder as a specific crime for which a criminal is on trial. This should be acceptable because the justness a policy of differential punishment should not depend on the crime.